first.
May it please the court. Good morning. I'm Dwayne Robinson. I'm here on behalf of the appellants, which I'll refer to as Zahav.
Sure.
I would like to request 5 minutes of my time for rebuttal. To decide this case, this court need only apply one of the clearest and most firmly established principles in all of the law, which is it is not the function of trial courts to rewrite contracts. The rule that courts do not rewrite contracts was dispositive in Arvilla Motel, which is binding precedent on this court, and it is dispositive here in this appeal as well. And for that reason, this court should reverse the trial court's final judgment below. Now, the appellee in its answer brief, ignores Arvilla Motel, doesn't reference it, doesn't cite to it. This court, this panel, does not have the luxury of the plaintiff appellee Whitehawk to ignore binding precedent. If I can turn briefly to the facts of our case, it is undisputed that the purchase agreement between the parties to purchase roughly 26 residential properties required a closing in 30 days. In fact, in the arbitration proceedings, the plaintiff, Whitehawk, specifically requested from the arbitrator 30 days to close. And if we were to look at the furthest reaches of the purchase agreement, it contemplated no more than 90 days from the signing of the agreement to a closing, and that's assuming the plaintiff gave a $25,000 extra non-refundable deposit to extend that additional 30 days to close. Here, it is undisputed, Your Honors, that the plaintiff waited more than 130 days to close on these properties. That's at the record at 298. This court should reject the two principal arguments of the appellee Whitehawk. First, Whitehawk contends that it would violate its statutory rights under the Florida Revised Arbitration Code to force Whitehawk to comply with the contract it agreed to be bound with. Whitehawk is wrong. The second argument that Whitehawk makes, which I'll address first, is this contention that it timely, quote, attempted to pursue a closing before the 132nd day. The contract is clear, Your Honors. Whitehawk was not required to attempt to pursue a closing. It was required to close, and it didn't do so until September 22nd. Now, what you've seen on appeal is Whitehawk attempt to shift blame and say Zahav is responsible for Whitehawk's delay in closing. Mind you, that there's a question. Mind you, Your Honors, there are no findings from the trial court that Zahav did anything whatsoever to delay the closing in this case. What Whitehawk has alleged, at most, is the reason for the delay was that Zahav, one, prevented inspections of the property, and secondly, that Zahav did not turn over documents, specifically leases, related to the residential properties. Let's address each of those one at a time, if we may.
Before you do, Mr. Robinson, if I might, I do have a couple of questions regarding the contract. There's two things that I am concerned about in terms of the contract's time is of the essence clause and the arbitrator's use of the word expeditiously. Does this contract, which does have an arbitration clause, have any provision that says confirmation of that award is necessary for finality of purpose?
Not that I can recall, Your Honor.
Does anything in contract indicate that confirmation is necessary to validate the arbitrator's finality?
Not that I can recall, Your Honor.
Then the court should look at the date of the arbitrator's award to measure expeditiously?
Correct. And by the way, Your Honor, that's the firmly established rule of law in Florida. When parties agree to submit their agreements to arbitration, what they're saying is we're allowing the arbitrator to resolve this dispute. The courts in Florida have held that arbitration agreements are binding even before confirmation. A party can't sit on its rights and not comply with an arbitration award until it's confirmed. And in fact, if we were to go back to what Whitehawk told the arbitrator, Whitehawk said, give us 30 days to close. It didn't say, give us 30 days to close from the confirmation award, that, by the way, under the revised arbitration code, could be as much as a year after the award has been issued. That clearly was not contemplated by the parties. The trial court was bound to follow the terms of the agreement, which were very specific, very detailed. In fact, as to the time of closing, the parties had to close by 5 p.m. Eastern. That's how crucial these parties treated the obligation to close. If we can go back to this issue about inspections, that question that Whitehawk is attempting to raise in this appeal is not properly before this court. Whitehawk moved to modify the arbitration award to allow for inspections. The trial court said no. Whitehawk did not appeal that decision. So the judge's decision is law of the case. So that issue is not before this court. If we can turn to the revised arbitration code, the other primary argument of Whitehawk is the code somehow granted Whitehawk the right to sit around and wait 90 days or 130 days to close. The arbitration code didn't know such thing. And there's a principal reason why it did not. Let's think about what is the relief that Whitehawk sought through the revised arbitration code. It sought the right to modify the award to request inspections that Whitehawk never demanded in arbitration. On the plain language of the arbitration code, it doesn't allow that relief. So there's no way the arbitration code is even applicable here to justify the delay. Beyond that, we point the court to the 11th Circuit's decision in Nuvasiv, in which the 11th Circuit, in interpreting the Federal Arbitration Act, which our courts look to as an analog to the Florida Revised Arbitration Code, the federal courts have said that the deadlines under the Arbitration Act are just that. They're deadlines. In other words, if you wanted the right to sue for modification, you could have sued on day 1. You could have sued on day 15. They chose to wait 90 days. They had the right to modify. They didn't necessarily have the right to wait 90 days if they had an obligation to move and move quickly. I'll say one other thing, unless the court has any questions. What I suspect Mr. Wolf may say in his response, since he didn't really provide one in the briefs as to our Villa Motel, is he may try to convince the court to remand for further proceedings. And as this court held in Tracy versus Wells Fargo, remand for further evidence proceedings is only allowed in exceptional circumstances. Whitehawk had the obligation to create the record below to justify its entitlement. Whitehawk failed to do so. So with reserving the remainder of my time, we're asking the court to reverse the final judgment and strike the demand for specific performance. Thank you for your time.
Thank you, Mr. Robinson. Okay, Mr. Wolf, you're up.
Thank you, Judge. May it please the court, Matthew Wolf on behalf of Whitehawk Asset Management. The issue before the court today is a narrow issue. It's the final judgment. The arguments raised by counsel in his brief and here today are well outside that issue. It's whether or not the court entering judgment was proper. And if you've read my briefs, which I imagine you have, the court was required to enter judgment. We had 90 days statutorily to seek to modify the award. We moved timely within that 90 days. The trial court judge ultimately denied my request.
You may have had a right under the code. What right did you have under the contract to wait?
You're right. There's no clause in the contract regarding confirmation is required to try and close.
Okay. So if your contract says time is of the essence and it provided for 30 or 60 days, how do you get there because you did or did not decide to exercise your rights? And I will let both parties know I'm looking at a case called Capital Factors out of the 4th District in 2007, found at 965 Southern 2nd, 1170A. And granted, it's a garnishment proceeding, but it talks about whether or not what the contract says, and we're talking about performance of the contract. And it pretty much indicates that confirmation is not necessary for finality. So if the arbitrator's award is final, then aren't we, for time is of the essence, measuring it from that date, which I think was early in 2022 or whatever, and that's 100 and something days probably. How is that time is of the essence or expeditiously? And that's my concern. There may be rights afforded by the statute, but the rights are to specific performance is afforded by the contract.
Yeah, and we tried to close immediately. There's in the record.
Closing date ever scheduled?
So the closing was scheduled through a closing agent. This was part of the contract. And the closing agent, if you've ever
scheduled a closing.
They couldn't because documents were never produced by the seller. If you've ever purchased a property and you went through a title closing company, they require certain documents in order to close. They have to run title, they have to make sure title is clear. The day after we received the arbitration award, it had been 7 months since we were supposed to close before Zahav breached the contract. And we asked for inspections immediately so we can proceed forward with trying to close on the contract. None of that was ever provided. That was what premised the filing of the modification request. If they would have produced that documents, my client would have closed within 30 days. But there's emails, correspondence between me and the prior counsel immediately the day after that award was entered, asking, can we proceed forward with inspection? And they wouldn't do it. They wouldn't produce documents even after the award was confirmed.
No definite response either.
Pardon?
And some of the responses to the emails were not exactly forthcoming, I guess you would say. Yeah, you're asking for things and they're not really responding to you.
Correct. And for lack of a better term, it takes two to tango in a closing. And if you want to close, this was 26 properties to close on 7 months after the closing was supposed to take place, the award was issued. I think it was appropriate to request these documents under the contract. And because they wouldn't produce this information, we had to seek the modification, and we sought it timely. Once that modification was denied, the court was bound to enter that final judgment, which is what's up on appeal today. This is a narrow issue, whether or not the court erred in entering that final judgment. And 682.15 says they have to, they shall. They don't have the option not to do so. And the odd part is, if you read the response and cross motion that was filed by Zahav, they agreed to confirmation. They actually put in bold, we are not objecting to the confirmation of this award. I don't think the court, when it entered its judgment, went outside the bounds of what the award said. The judgment said you have to close expeditiously. The award said you have to close expeditiously. In order for us to enforce the award, we had to obtain the judgment so we can move forward.
To cut this, what the argument is the only narrow issue, the discrete issue on appeal, is whether the trial judge erred in approving the final judgment of the arbitration award. The issue is not whether it was a contract to have a closing.
Correct. That's what's up. That's what's on appeal is the final judgment. Sorry, I'm just getting a little feedback.
That's okay. I got it.
And I cited the case in my reply. The standard review today is going to be abuse of extremely limited discretion. The court had no authority to go outside of Florida Statute 682.15. It says you shall do so. The cases I cited, the Candalis case, the Wells case, the Carpet Concepts case, they all have language in there saying that the court was required to confirm the award and enter the judgment. So when we were in front of the trial court judge, she had no other authority but to enter that judgment unless somebody was seeking to modify it or vacate it. So we believe the entry of the judgment was proper. We believe that the issues that are raised in the appellant's brief, I think, are outside the scope of what the court should be considering today. The court should be considering whether or not the entry of that final judgment was proper, not the factual disputes, because we dispute this timeline that they argue in their brief, and we disputed at the hearing. We've disputed everything that we filed. You can see from my emails with prior counsel that we were trying to move forward, but that's not the issue before the court today. The issue before the court is, was it an error for Judge Polo to enter that final judgment? And our argument is it was not an error. It was not an abuse of extremely limited discretion, because she was bound by Florida statute to confirm that award under 682.12, and she was bound by Florida statute to confirm that award by 682.15. And Zahav had its day in court. They argued this, they raised in their brief that they had the right to raise defenses. I think that was under the Meade case, that there were certain defenses they wanted to raise. The Meade case was a situation where it goes to arbitration, the arbitrators determine damages, and then back in front of the trial court, the insurer is saying, well, this is outside the policy limits, we should be able to raise that as a defense. And the court agreed. It said, yeah, that was never in front of the arbitrators to determine what the policy limits were. They had their day in court. They showed up, they attended. If you read the transcript from that hearing, they argued this exact issue that they're arguing here today. So the fact that they're arguing that they weren't properly in front of the court on their defenses, I think, is without merit. All you have to do is read the transcript. At the hearing, they even had a demonstrative aid that laid out the timeline that they're alleging of what took place. So I think that argument should fall on deaf ears, because they were there. They had their day in court. They had their due process. It was properly in front of the judge to consider. So I think if the court looks at what we're here for today, this narrow issue of whether or not judgment was proper, I think the court has to affirm what the trial court did, has to affirm that final judgment. Unless your honors have any questions for me, I don't have anything further.
Mr. Wolf, I've got one question. Did the court ordered that the property and the transaction close expeditiously? Did the court make a determination as to the timing of closing, or did the closing just get set and it closed, or it didn't close? What happened after the judgment was entered?
Well,
only if our record tells us this. So, because clearly the appellant is arguing that expeditious has a reasonable meaning to it, and the closing did not occur expeditiously. So what does the record tell us happened once the judgment was entered?
Once the judgment was entered, there's nothing for the record except the appellate issues. But I think what's important is the transcript from the hearing, where Judge Polo discussed what she felt was expeditious. She went through a long rendition that she'd already ordered us to close, that we need to get this thing closed, that there should be no delay, but she never defined what expeditious was for us. And unfortunately, that's been a long-standing issue in this case. When the arbitrator entered their award, I believe it's in the record, Zahav moved to modify the award, which was denied by the arbitrator. And then part of my motion to modify under 682.14 was further clarification, which was again denied. So we haven't, in my opinion, we haven't gotten a strict answer on what it means to close expeditiously. What we were told in the transcript is that if we didn't close, I don't have the date in front of me, she gave us a date certain that the parties would be fined $100 a day moving forward. But never did we receive the directive, hey, you have to close by November 15th or you're out of compliance. Nobody's told us that to date. And in the record, and I think it's even agreed by Zahav after that judgment was entered, there were multiple closings scheduled. And again, it takes two to tango. Part of my response that's in the record were emails from the title company saying, we're trying to get information from these sellers. They're not producing it to us. We can't give you a closing date until you provide this information. If there are not any more questions, I'll yield the rest of my time.
Thank you, Mr. Wolf. Okay, Mr. Robinson. What?
Judge Silverman, I'd like to start by addressing your question that you addressed to Mr. Wolf. So after the final judgment, the trial court stayed the judgment, and so there was no further closings. So that's the answer to your question. You also had the question, Judge Silverman, whether the trial court made any findings as to when expeditious is. I would say the trial court did observe at the September 7th, 2022 hearing, and that's at the record site of page 290, page 14 of the transcript, lines 20 through 22. This was on the 117th day after the award. The judge said, so the award was issued on May 13th. Expeditious has already expired. Okay, we all know what expeditious means, and 130 days just ain't it. And I'm very surprised that my friends on the other side still have not addressed our Villa Motel, the precedent that controls the disposition of this case. That is very telling. Now, I want to address very briefly, with the little bit of time I have left, what Mr. Wolf said about why they had to move to modify. He told you all just now, he moved to modify because he needed documents and didn't have that. False. Look again at the motion to modify. The motion to modify said we need to modify to have inspections. Inspections was the reason that they gave why they couldn't close. They did not raise this claim about documents until December, when we opposed the final judgment that would grant them specific performance that wasn't allowed in the terms of the agreement. Mind you, Your Honors, this is a special case where the arbitrator had a ruling after the arbitration award. And the arbitrator said that his job was not to write terms into the contract as to what expeditious meant. The arbitrator said the contract is what governs the time period to close. And it's undisputed. Under any reading of the contract, that Whitehawk did not close in that time period. I would also say that saying the parties must close expeditiously on May 13th, 2022 is different than saying that in December 29th of 2022, which is when the final judgment was entered. Expeditiously had an entirely different meaning between those 2 points. The contract was not being followed. The trial court rewrote the contract, and this court must reverse. Finally, regarding Meade, the decision's about 2 or 3 pages long. The court and its clerks can review it. Mr. Wolf misunderstands what that case is about. That case is not about whether or not the appellant has the ability to raise an argument in the trial court and therefore Meade is satisfied. What Meade recognized, which is a Florida Supreme Court, this court is bound by, is that there is a defense to confirmation where there's an issue that was not and could not have been raised in arbitration, and the parties can raise that defense in arbitration. And so what we're asking here is the court remand for entry of final judgment that even if it confirms the award, it finds the plaintiff did not act expeditiously under the plain terms of the contract, and therefore its relief for specific performance should be denied. So for those reasons, we ask the court to reverse. Thank you for your time.
Thank you both very much. In order to be gone from our virtual courtroom, you need to click the leave button that is on your Zoom screen, and you'll go away.
Thank you.
Good. Okay, the court will be in recess for 10 minutes.